Minus function and mention a case from the list. It's serial number 22. This means I'm asking Malwas Intelligence to take up this case in the first half. So in the second half, I have to go to the
तुम पता नहीं है क्या मैटर
But this is a restoration matter.
रेस्टोरेशन में क्या एजेंसी है
Restoration, the petitioner is in custody. Petitioner is in custody.
देखते हैं we cannot see.
First half was impossible because we have taken an appointment from the doctor at 3 p.m.
कोई बात नहीं इनको डेट दे दीजिए
So करना जरूरी क्योंकि कस्टडी में है काफी दिन से 7 महीना से आउट ऑफ 1 ईयर में कस्टडी फॉर 7
देखिए अभी ऐसे सुबह नहीं होती आप सेकंड हाफ में आइए यू कैन नॉट से जब केस कॉल आउट होता है तब आना चाहिए था ना पिछली बार गाइड डीएफडी
डीएफडी हुआ तो वही सरेंडर सर्टिफिकेट फाइल
ठीक है आइए सवाल हो जाए
Orders with
Get
effect
hold of the
from
others.
supplementary list.
That's my file please
Item 2, filing number first appeal 10976 of 2022.
There is a thing that I may be permitted to withdraw the petition on the last date. Your Lordship pointed out to check whether this Honorable Court will have the jurisdiction to entertain the appeal or not, because as per the Jharkhand notification, it has created 2 levels of commercial court. One is the civil judge.
it has been wrongly filed before
It has been wrongly filed.
Thank you.
So I'm only bringing this.
FA number filing number FA 10976 of 2024 your name please
The Salish Court.
Mr. Salish Poddar
Yes.
advocate has sought permission to withdraw this first appeal in view of the by submitting that this appeal has been wrongly filed before this court. It ought to have been filed before the
Learned District Judge will also.
learned
Ranchi.
district judge Ranchi.
Ranchi will also.
The impugned order in the present case has been filed ऊपर लिख देंगे पूरा है ना has been passed by learned presiding officer commercial court Ranchi. Considering the aforesaid submission, this appeal was filed before this court on 16/10/2020. Considering the aforesaid submissions, this appeal is dismissed as withdrawn with the liberty to the appellant to file appeal before the appellate authority constituted under the provisions of Commercial Courts Act read with the notification issued by the state of
State.
the office is the court fees का क्या होगा?
Because that defect had not come because the issue was on maintainability.
Court fees has not been
Abhi
filed.
that's not filed and not pointed out by the registry so far, because it wasn't the point whether it's
That should be sufficient.
That's plus any limitation will not, because
इसीलिए मैंने डेट ऑफ फाइलिंग लिखी.
अच्छा ठीक, great,
बाकी आप अपना वहाँ
ठीक, great.
आइए क्या चीज़ का था?
It's for withdrawal only. This was the IE
For
for
withdrawal.
withdrawal. Yes, ma'am. This was the IE for withdrawal.
आइए has been filed seeking withdrawal of this हाँ आइए number 1786 of 2025 has been filed for withdrawal of this petition which is hereby allowed. Sorry? हाँ ignoring defect closing. इसको ठीक से देख के बनाएंगे है ना आइए कौन सा है कौन सा नहीं.
From daily list for final disposal item 2, second appeal 381 of 2017.
Mr. Mehta, your judgment is under correction. आप ही का मैटर है ना जजमेंट पर आज. It is under correction. 4 बजे तक हो जाना चाहिए. इन केस अगर नहीं होता है तो हम कल सुबह के लिए कुछ फाइनल करेक्शन ज़रूरी है. जजमेंट होने के बाद तो कुछ ही नहीं कर सकते ना, जो करना है करेक्शन पहले ही करना। वैसे आई विल ट्राई कि 4 बजे तक हो ही जाए। यस, दिस इज फॉर ऑर्डर्स,
No, this is the final.
फाइनल डिस्पोजल। ओके, respondent is not appearing.
There is no.
Respondent number 1 has appeared by filing वकालतनामा. Who is for respondent number 1? He is appearing for respondent number 1 and 2 both. How many respondents are there?
One is Bharatnath Keshari.
Respondent number 2 is the state.
State.
So state को तो कोई मतलब नहीं है. Let them not come. State अपनी suits में अपने appearance को कोई आता नहीं है ना? आते हैं? लग तो नहीं रहा है, हम तो एक भी बहुत कम ही केसेस में स्टेट का अपीयरेंस देखते हैं। We are not bothered about it. ना रिटन, इसमें रिटन स्टेटमेंट फाइल किया था स्टेट?
No.
नहीं किया था ना, तो इसीलिए दे आर नॉट इंटरेस्टेड।
Yeah, actually, my matter is one of the party is scheduled tribe.
Sorry?
There is a scheduled tribe. That is the
इसीलिए
reason why
they are necessary party. But they are not formal parties.
No, admitting.
They are not.
The nature of
They
dispute
assume that they are formal parties. They are not formal parties. They are to represent the interest of the scheduled tribes.
46(3).
सरकार का पॉलिसी है नहीं अपीयर होना, तो हम लोग क्या कर सकते हैं? ये अपीयर ही नहीं होता है। I just don't know. GP had appeared. He is appearing before the learned.
Written statement.
ना रिटन स्टेटमेंट नहीं फाइल किया तो क्या ही किया अपीयर करके? अपीयर रिटन स्टेटमेंट अगर डिफेंडेंट नहीं फाइल कर रहा है और अपीयर कर रहा है तो वो ही इज कॉलिंग फॉर अ जजमेंट व्हिच इज बाइंडिंग ऑन देम.
Okay, he can cross-examine the witnesses and
That's
he can
right.
argue. He can make arguments.
Anyways, they are not interested. We don't care about it. चलिए आप बहस करिए. Private respondent is also not interested. पहले substantial question of law देखते हैं. You are the plaintiff defending.
I am the defendant and the plaintiff has instituted suit for eviction. That was decreed. There were two grounds.
Just a
One was-
moment. Appellate order confirmed it.
Yeah.
There is landlord-tenant relationship.
Yeah, no. They had instituted a suit on the basis of two grounds. One was default in payment of rent, and another was personal necessity. That was the two grounds they have taken. And we appeared and we filed the written statement, and there was a denial on our part. I said there is no written.
Denial of default.
No, there
There is no relationship of landlord.
relationship itself. Learned trial court under
Just a
the
moment. Note करना.
Our claim, Your Worship, is that we are the descendants of one Kail Uram, who was the recorded tenant.
Descendants of
Kail Uram.
Kail,
Kail.
the recorded tenant.
Yes.
And therefore you are the owner of the property. The property was recorded in the name of Kail Oram. क्या
Yeah.
हुआ?
पता नहीं उसका microphone
इसको ऑन करिए.
ठीक हो गया.
ठीक है. Okay.
ठीक.
Kail Uram was the recorded tenant. And we are his descendants, that is our claim. Our claim is that this suit property is of Cal Law, and the plaintiff, he is son of one Bansilhar son. He claims himself to be that this property under section 73(2) of the Nagpur Tenancy Act, it was actually he got that is his claim, and to that effect he has brought documents also under court. But there is no surrender, nothing like this, and learned trial court under erroneous impression that 14(4) leave is required to be taken. On the ground of personal necessity, he or admitted the evidence that you know you
No,
are.
I don't get it. Please let us know. That let us see first 73(2). There is a procedural error also, it seems.
Yes, it's a total processual error.
Okay.
In
So
my
what
mind,
is the procedure? according
yes.
to you?
First of all, when a suit under a personal necessity is only filed,
Yes.
then only under the old act, it is 14(8), section 14, under there is a special procedure.
Okay.
That is only for the personal necessity. But when a suit is filed under the provisions of default as well as for personal necessity, then the general principles will follow. It is not only the so that aspect was totally ignored.
So that is of a absolutely summary nature, personal necessity under section 14.
Section 14 is a personal necessity,
Yes.
and when a summons are duly served, then the law as per the section 14(4), it mandates that there should the defendant should file a leave application first, and if the leave is granted, then only you are allowed to contest, otherwise not.
Okay.
That what is the law. Learned trial court on that basis that you could not file a leave application, so you divide and admitted the entire case of the plaintiff. On that point, actually decreed this, mainly on that. And
So-
apart from that, he considered that there is a relationship of landlord-tenant also. So both the points he considered and he decreed.
He
Appellate-
decreed on personal necessity as well as on default.
Yes, both. On personal necessity, he said that you could not take any leave, so you have no defense virtually.
He will not, it is not severable.
No, when it is filed under two clauses, there is two of the clauses, then there is a judgment of our full-time judgment. A general law has to be.
That's
Your Lordship may kindly see that.
So according to you, if this point is decided in your favor, nothing remains?
That is one of the points which has been framed by this law. That has been one of the points that has been framed.
Let us-
Apart from that, Your Lordship,
Yes.
apart from that, this matter, Your Lordship, is not of a landlord-tenant relationship. In this matter, questions of titles are involved, complicated issues are involved, where there is a istifanama.
Has the plaintiff, did they depose on the point of any payment of rent?
No, there is no
evidence.
written document. There is only oral, and there is no rent receipts also.
There is no rent
No
receipt.
receipts also. And Malad, apart from that,
Tenancy is since when, according to the
they are
plaintiff?
claiming that tenancy is since Malad. 2005. Their claim, Your Lordship, that he has come to the village, this defendant has come to the village, and the premises was let out to him on a rent of ₹100. And he paid the rent till 2007, and thereafter the suit was instituted. When he stopped making payment rent, etc. Their main claim, Your Lordship, is that under 73(2), this property was given to Councillor Saab. And
Now let us see the substantial question of law
yes,
thing.
yes. Whether the learned, it is ordered dated on 27th of September.
Yes, I am there. I'm. Can you
May I
read?
read?
Yes, yes.
Whether the learned court acted illegally in declaring the suit for eviction by wrongly applying the principle of law in the matter of eviction suit brought under Jharkhand Building Lease Rent Eviction Control Act. Whether in absence of the relationship of landlord and tenant as according to provisions of Jharkhand Building Lease Rent Control Act 2000, the decree for eviction is perverse and erroneous and can be sustained. Whether the findings of the learned court below are perverse and contrary to certain principles of law that complicated disputes of title cannot be decided in eviction suits. Whether the finding of the learned court below decreeing the suit by resorting the provisions under section 44 of Jharkhand Building Lease Act Control Act 2000, taking a special procedure, can be sustained in the eye of the law when the suit was included with other grounds, including the ground
Roman 1 and Roman 4 are primarily one and the same? 1 and 4.
1 and 4.
Because 1 is quite vague. So Roman 4 is 1. Roman 1 and Roman 4 are primarily one and the same,
Yes.
according to you. This is the main violation.
This is one of the main violations.
What other violation?
What other violation
Is Roman 2 and 3
suit itself was not. Your Worship, I can't
on
go.
account of complicated.
Complicated questions of law, and such pleas are formal pleas, and they usually to evict the person, a genuine person. Such pleas are often taken, and
By default, they are taken.
and if you say that I have given this premises to you on monthly rent of such and such, and if suppose you,
What is your explanation so far as the possession of the defendant is concerned?
Possession?
Yes. What is the explanation of the plaintiff? Plaintiff says that you were inducted as a tenant. You say that you are there on the property by virtue of your own right.
yes.
Yes. Since when? What is the earliest possession you have shown? What is the earliest document of possession? Because they are claiming tenancy since 2005.
Yes.
Is there anything on record prior to 2005? Rent receipts in your favor? Rent receipts?
Rent receipts, there are certain rent receipts. Ghar Sumari receipts, Chaukidari and Ghar Sumari receipts have been brought.
By you? By you?
By us.
What is the date?
I could not check out the records today. I would
आपके
like to see.
एग्जिबिट्स में होंगे ना? एग्जिबिट्स में होंगे?
It
तो
is
इसमें नहीं लिखा हुआ है?
इसमें
एग्जिबिट नंबर बताइए?
डिटेल्स में नहीं। एग्जिबिट ये एग्जिबिट जो है वो A and B।
एग्जिबिट ए एंड बी। दीजिए जरा उनको रिकॉर्ड कीजिए।
Khatiyan has also been brought up.
Khatiyan is one thing. We just want to know.
No,
Exhibit A and
it is in a limited position that the property recorded in the name of the creditor. ये 2006 का लिखे 2006 का है 2008 का। करंट रिसीट तो उनका है उसमें
What is this? There was a document filed on 14/6/2013 before the appellate court, before the trial court.
that is one eviction suit. He has
Yes,
brought-
eviction
yes.
suit of 2009.
They-
What is this Exhibit C?
Plaintiff has brought another suit against one Sunath Rao, who is my brother. That suit has been dismissed.
On what ground?
That there is no landlord tenant
Against your brother?
against my brother. But the property is almost same, khata number, etc., etc.
It is the adjoining property.
Actually, yes, Kail Rao was.
It is the same khata number. What is the discussion of Exhibit C by the learned trial court and appellate?
Learned trial court has said that original copy, etc., is not been produced.
Exhibit C. Exhibit C is a certified copy obtained from eviction suit.
But learned appellate court has written this. That is also apparent error.
Exhibit C is a certified copy,
Yes.
marked exhibit.
Yes.
Where is a discussion of Exhibit C?
But court has not relied upon it.
So that makes the judgment perverse, isn't it?
Yes.
That's a material document.
Yes. I am reading it. Relevant paragraph here is 11, page 11. Page 16, running page 16.
Yes, and
Learned trial court has written, learned appellate court has written that DW3 is a formal witness and has proved summary receipts were marked Exhibit C is a certified copy obtained from eviction suit and relates to entry of name of value. This document was filed on 14/6/2003 after examining all the defendant witnesses. A petition was filed with request that same may be marked as exhibit. It is a public document and symbol thereof. The discussion I am reading. Yes, next one. Defendant has pleaded that he is a descendant of Kail Rao, but he has not filed any document to show his relationship with Kail Rao. Original entry register of CS Katyan was not called from eviction suit number 2 of 2019, but it is certified copy was filed after examining all witnesses of the defendant. Had the document been filed earlier, the plaintiff would have an opportunity to draw attention of witnesses during their depositions. Except this document, only two summary receipts in support of claim of the defendant. These two receipts are obtained after filing the suit and does not show anything except the position of the defendant, which is the case of the plaintiff. And the defendant
no,
has
the point
pleaded-
is that once the document is admitted as evidence,
But
then the witnesses could have been called upon for further examination, isn't it?
yes, Malad, section 707 of the Malad
Yes.
Code of Civil Procedure, the Lordship will find that the learned appellate court has wider power than the trial. Your Lordship may kindly see section 107 of the Code of Civil Procedure.
But once it is admitted as evidence, the court cannot say that they have not been granted the opportunity to cross-examine.
Then Malad,
Then there is a
report-
procedure.
No, there is a-
Even the trial court could have taken that procedure.
No, it was filed before the appellate.
It was filed before
My
that.
Lord may kindly, in such conditions.
No, this was filed on 14/6/2013. Eviction appeal is of 2015.
Yes.
So it was filed before the trial court itself.
No, it was not filed.
Then how is it mentioned?
It
This
is-
document
it
was
is-
filed on 14/6/2013.
But
No, it was filed before the trial court itself.
2015 is the appeal number.
Yes. And this was filed on 14/6/2013 after examination of all the defendant witnesses.
Yes, Lordship.
And this Exhibit C does not find discussion in the trial court judgment.
Not at all.
उसमें तो कहीं नहीं है, हमको तो नहीं दिख रहा है कहीं, बताइए देखकर.
Apart from that, if the appellate court was to rely on that document, then he could have remanded the malady. So for that point also, it is not in accordance.
Exhibit C में लिखा हुआ है certified copy of CS खतियान, trial court का judgment.
ट्रायल कोर्ट का इसमें भी है, CS खतियान उसमें फाइल हुआ, लेकिन इसमें जो इसमें अवेलेबल जो है उसमें वही देखा.
Exhibit C क्या है जरा देखिए.
CS खतियान.
दो Exhibit C तो नहीं होगा ना, ये जजमेंट कौन सा है, ये एग्जिबिट कौन सा है?
खतियान एग्जिबिट डी बता रहे हैं, एग्जिबिट सी जो है CS और खाता लिखे.
Exhibit C.
एग्जिबिट ए है वो सुमारी रिसीट है.
हाँ, नहीं. ये यहाँ पे appellate court कैसे लिखा है? This document was filed on 14/6/2013. ये कहाँ फाइल किया है? appellate court में कि trial court में? Additional evidence.
Additional evidence के तौर पर नहीं दिए हैं.
दिखाई जरा appellate court.
डाले हैं तुरंत एडिशन शूट का ऑर्डर था.
ये कहाँ से आ रहा है?
इस कोर्ट को नहीं डाले हैं. उसमें जैसा उसके लगने को हो सकता है ट्रायल कोर्ट में फाइल किया होंगे, लेकिन आफ्टर एग्जामिनेशन के बाद किए थे, इसलिए अपील कोर्ट में मेंशन किए थे, उन्होंने माफ कर दिया. लेकिन वो एग्जिबिट सी वो नहीं है जो एग्जिबिट सी है. जजमेंट है लेकिन देखा प्रोसीजरल एरर भी है. प्रोसीजरल एरर, this is not the way this shoot should be conducted on our part also. And
Now, let us see the procedural error
yes,
first. सब जजमेंट बताइए कौन कौन सा पहले जजमेंट. इशू नंबर 1 and 4 का तो एक ही जजमेंट आप रिलाई करेंगे. द सेक्शन 14(4) will not apply.
फुल बेंच का जजमेंट. अपने हाईकोर्ट का फुल बेंच का जजमेंट
प्लेस करिए प्लीज. बताइए.
Para 9 and 10, relevant para.
पढ़िए.
From perusal of the said provision. para 8 में provision लिखे हैं. para 9 पढ़ रहे हैं. From perusal of said provision, it would be evident. para 8 ही पढ़ते हैं. Section 11 of the Act prohibits eviction of a tenant except in exclusion of a decree passed by the court on one or more of the grounds mentioned here. One of the grounds as contained in Clause C of the 11(1)(c) of the said Act for eviction of tenant in terms of the provision. Building is reasonably and good faith is required by landlord for his own occupation or for the occupation of any person for whose benefit the building is made by the landlord. From a perusal of said provision, it would be evident that the suit for eviction can be filed by grounds or more than one ground as specified there. Section 14 of the Act, however, provides a special procedure for disposal of cases for eviction on the ground of bona fide requirement. On the ground of expiry of the period of lease as specified in Clause C of the or Clause E of the Section 1 of Section 11. Section 14 therefore carves out an exception from the general rule that in a suit for eviction filed by the landlord against the tenant, the procedures laid down under the Code of Civil Procedure would be followed. From the combined reading of Section 11 and 14 of the Act, therefore it becomes clear that the special procedure laid down under Section 14 of the Act can be taken recourse only in a case where the ground for eviction is covered by Section C, Clause C or E of the section, subsection 1 of Section 11. Where, however, the landlord chose to join more than one grounds of eviction, which may include one of the grounds specified in Clause C or Clause E of the subsection 1 of Section 11, the general provisions laid down for deciding a suit shall be applied. My lord, in this particular case, in the case in hand, the ground of eviction was two. One was default, another was personal necessity. Had it been a case of personal necessity, then my lord, special procedures, other my lord, leave, etc., was required. So that is one of the procedural error my lord, which the trial court has conducted, and appellate court has also my lord, gone insane.
How are you prejudiced by this procedure?
My lord.
How are you prejudiced by this procedure? There is no regular written statement to be filed
No, the regular written statement is to be
under Section 14 normally.
no.
What is the procedural difference between the two?
This.
And how are you prejudiced by the fact that Section 14 has been invoked by the learned trial?
No, in this particular case, what has happened, the case in hand, that my lord, he filed an eviction suit under two clauses.
That's
First
right,
was
I have got
default
that.
and another was personal.
Yes, got it.
Thereafter, after my lord, issuance of suit, we filed a regular my lord, written statement,
Okay.
which was in accordance.
Then
Had it been only
what happened?
then my lord, the learned trial said no, leave is essential. And personal necessity aspect he admitted leave.
After granting leave.
Because you have not taken any leave.
Okay.
And at the appellate court also has said
So that order was not challenged by you. What was that order?
that order the suit decree. That was challenged.
The final decree is primarily this only, that
The-
without any leave your written statement has been filed.
That is one of the points. And so far as the default in payment of rent is concerned, then a trial court as well as the appellate court has taken into ground, and despite there is no rent receipts, nothing like this, there is no written agreement, only there are some oral evidences.
No, I don't get it. You see, on account of not taking leave,
Right.
The learned trial court held that written statement could not have been filed.
Yes.
Right?
So far as the personal.
Oh, so that portion they had segregated.
That was not even taken into consideration.
So the decree is on account of default and personal necessity both.
Definitely. So that is a procedural error. What was the perversity and what was the misconception in the mind of the
Let us see the trial court.
Yes. Malad, मैं kindly see Malad, page running page 27.
Running page 27.
Yes. First of all, I would like to show the issues because the issues are being referred. It is at page para 4, page 25. Suit maintainable has a plaintiff any cause of action, suit barred by law of limitation, whether suit suffers from non-joinder of necessary party, whether there is a relationship of landlord and tenant, and then whether the plaintiff is entitled to get the other reliefs or reliefs claim. Then you also may kindly see para 6. Issue number 5 and 6.
Yes.
Issue number 5 here, Laship, is there a relationship of landlord tenant, and 6 is entitled to get relief. First of all, let us consider the case of a defendant in the light of section 14(4) of the Act. Plaintiffs have filed the present suit for areas of rent and for personal necessity, and once these two regions are being assigned, the suit needs to be tried summarily. As provided under section 14(4) of the Act, defendant first have to submit an affidavit showing reasons for contesting the section 24. Then the court has discussed it, 14(4). The tenant on whom the summons is duly served, whether by ordinary mail or by registered post, shall not contest unless he files an affidavit stating the ground on which he seeks to make such contest and obtains leave from the court, as hereinafter provided, and in default of appearance in pursuance of summons or obtaining such leave, the statement made by the respondent in the suit for eviction shall be deemed to be admitted by the tenant, and the landlord shall be entitled to an order of eviction on the ground efforts. On bare perusal of aforesaid section, plaintiff has to show his status as a landlord and a status of defendant as tenant. Onus upon plaintiffs to first prove his position as landlord over the land in dispute. Landlord term has been defined under section 2F of the Act, which includes the person who for the time being is receiving or is entitled to receive the rent of the building. That is to say, the plaintiff has to show his entitlement of receiving the rent in whatsoever capacity as provided under 2F of the Act. In support of the plaintiff has produced certain documents, including the order passed by DC in case number 1 of the 1940-41, wherein after complying with requirements and under section 73(2) of the Act, an order was passed in the favor of the father of the plaintiff pertaining to the land in dispute, and notice as required for state provision has also been filed and marked as Exhibit 3 and 3, and transpires that the notice was duly published and no objection was filed by villagers, and after expiry of mandatory probate period as provided 73(2), final order was passed on 21st of July 1940 in favor of the father of the plaintiff, including the land in dispute. Furthermore, certified copies of K form, I form, M form as required under the relevant provisions of the BLR Act has also been filed and been marked as exhibits with objections by the defendant. But the Objections so raised by the defendants has neither been countered by the defendant nor any documents has been filed by them to disprove the same. Hence, document filed by the plaintiff shall be taken into account and evidence on behalf of the plaintiff which suggests that the land in dispute was divested in the name of the father of the plaintiff after due compliance of relevant provisions, and the rent receipt was issued in favor of one of such rent receipt has also been filed by the plaintiff, which is marked as exhibit 2. The defendant during the course of argument has raised objection that plaintiff does not lead evidence with regard to abatement of land in suit, which renders the entire proceeding initiated by Deputy Commissioner in case number such and such void ab initio. The objection so raised by the plaintiff is not maintainable in the light of the evidence and documents produced by the plaintiff. Even otherwise, this is not the forum to discuss the maintainability of order passed by the DC while exercising his jurisdiction under CNT Act, and the defendant has failed to adduce any evidence with regard to filing of objection under the order passed by DC in case of 1941-40-41. Further, the suit relates to eviction and the court should avoid in going into the question as to the ownership in the dispute, but passing reference may be taken if the facts of the case so required. In this case, establishing the locus standi of the plaintiff as landlord, it is necessary and incumbent upon the court to make observations with regard to genuineness of the document desired by the plaintiff. Documents and evidence so produced and exhibited by plaintiff are sufficient to suggest his entitlement, claiming this entirety as landlord and land in dispute. Furthermore, plaintiff during the chief has corroborated the entire pleading and his plan has been duly cross-examined. The area of rent and the personal necessity of the has been duly substantiated. Nothing material in contradiction therefore has surfaced during the same cross-examination. In addition thereof, the plaintiff has also examined one of the witness, PW2, who has supported the contention of the plaintiff and reiterated the plaintiff let out the land in favor of the defendant. PW deposed that the defendant took the said house on rent and plaintiff for a monthly rent of 100 and also deposited 200 every month. Nothing material has surfaced during the entire cross-examination which substantiate the testimony as reliable. Hence, on the basis of aforesaid observations, I am of opinion that the plaintiff has successfully proved his status as a landlord and that capacity is entitled to claim the rent from the defendant. After coming to conclusion, now the requirement of section 14(4) of the comes into
Just a moment. The learned court recorded a finding that there is a landlord-tenant
Yes.
relationship on the basis of the evidence material placed on record. These were the evidences discussed.
Oral evidence.
Whatever be the evidence, oral, documentary or whatever. Some documents were also produced by the parties.
No, document is not with regard to tenancy.
No, document is with regard to ownership of the land.
Yes.
Certain documents were also produced to show the ownership of the land.
Yes.
And after those documents, he said, and so far as oral evidence is also concerned, the court came to a finding that there is a relationship of landlord and tenant.
Yes.
And after having given that finding,
Yes.
the court enters into the section 14(4).
Yes.
Yes.
Filing of affidavit and seeking leave to defend the case by defendant are the mandatory conditions under section 14(4) of the Act, in absence of which the entire evidence taken by defendant shall be read as null and void, and averments by plaintiff in the plaint shall be deemed as admitted by defendant. And this has also been observed by Honorable High Court in the following cases. Then cases have been referred, and in the instant case, the defendant has also failed to file an affidavit relying on the observations made by the Honorable High Court. A detailed statement filed by him shall not be taken on record, and accordingly, the evidence adduced by him shall also not be taken. The case shall be heard as an ex parte proceeding against the defendant, and the evidence adduced by plaintiff shall also be taken into account. And the court shall now have to examine the plaintiff in the light of the evidence in the form of oral as well as documentary evidence in support of his case. Plaintiff has fully supported the entire case met through the plaint, through the chief, and he has stated that his bona fide requirement of land dispute is personal necessity, and the contention so met by the plaintiff has duly corroborated by the other two witnesses. In this regard, the defendant has raised the issue with regard to availability of alternative accommodation of the plaintiff. In this regard, it is pertinent to mention herein the defense so raised by the defendant is not maintainable in the light of the restriction imposed by section 14(4) and once admitted, defendant not to be proved by the plaintiff, and in fact shall be deemed to be admitted by the plaintiff once he failed to file.
There is no finding on default.
Default यहाँ पे कहीं
कहाँ पे?
successfully proved.
नहीं. After coming to
That's
the
on the
conclusion.
basis of a topside observation. I am of opinion that has successfully proved his status.
Status of landlord.
That
Default का तो कोई finding नहीं है.
नहीं भी, उस पर भी नहीं
उस पे कोई finding नहीं है.
फंडिंग ये इस इरोनियस इंप्रेशन में
डिफॉल्ट का फाइंडिंग नहीं है, लैंडलॉर्ड टेनेंट रिलेशनशिप का फाइंडिंग दे दिया है और उसके बाद सेक्शन 14 को रेफर करके आपका सारा एविडेंस को खत्म कर दिया एंड द मैटर हैज बीन ट्रीटेड एज एक्सपर्ट. यही है फाइंडिंग. कहाँ है डिफॉल्ट?
एक्सपर्टी भी नहीं है तो
मैं एक्सपर्टी ट्रीट कर
ऑफ द प्लेंटिफ एंड डिपेंडेंट डायरेक्टेड टू वेकेट, वो भी नहीं लिखा. एक्सपर्टी है कि नहीं, वो भी नहीं. लेकिन जजमेंट रिलाई किए हैं उसके आधार पर
डीम्ड एडमिशन.
यही समझ है.
एरियर्स पर डीम्ड एडमिशन बोले.
डिग्री इनका कर दी है और इनका जो भी प्रेयर था इसको मान.
अपीलेट कोर्ट क्या की है?
इनका दो ठो प्रेयर था जो डिग्री ऑफ इविक्शन ऑफ डिपेंडेंट ऑन अकाउंट ऑफ ऑथेंटिसिटी एंड डिफॉल्ट may be passed and defendant be directed to vacate the house within time to be fixed by court.
अपीलेट कोर्ट का क्या फाइंडिंग है with regard to landlord tenant relationship? And it was your specific case that you have never paid rent. ये तो आपका specific case ही होगा.
I am not a tenant. It's our property of our ancestors.
बट फॉर्म एम वगैरह में आपका नाम नहीं है.
फॉर्म एम में तो खुद जो लैंड तो खुद है लैंडलॉर्ड. बिहार लैंड रिफॉर्म्स एक्ट के बाद ये सारा डॉक्यूमेंट्स अपना कर लिए. तो ये जमींदार थे, ये जमींदार के लड़के हैं. अच्छा एक चीज और भी ये अपीलेट कोर्ट का फाइंडिंग है जो कहूँ. कोई पॉइंट ऑफ डिटरमिनेशन.
There is an order under section 73(2) of CNT Act way back on 22/7/1940.
I agree with.
Much before vesting.
Much before this.
And by virtue of that order, the right of the recorded tenant is lost.
My lord may kindly consider.
Yes, there is sufficient material to
have-
hold
I
that
have-
they are the owners.
I have gone through those documents that they have brought on record. इसमें इनका कोई इस्तीफानामा नहीं. कोई इस्तीफानामा 72 देखा नहीं.
But still, there was a requirement to give a finding as to under what capacity you were holding the property. Even if it is held, prima facie, इसमें तो prima facie finding होता है, कोई declaration of title तो होता नहीं
That
है.
is what I am stating. This is a case of not a case of eviction under landlord-tenant relations. Complicated issues of are involved. Whether there was a istifa, whether actually under 73(2) proceeding.
No, but once there is a proceeding under section 73(2),
What may kindly appreciate.
and which stood decided in favor of the.
My lord may kindly appreciate. There is a khatiyan which is in the name of the ancestors of this party. That is an admitted document. And my lord,
खतियान was prepared when?
way back now.
Which 1932 का होगा खतियान?
नहीं और उसके बाद
कब का है खतियान बताइए? What is the date of खतियान?
निकला तो है 2013 में, लेकिन है पहले का।
खतियान
ये,
कब का है?
आप सही कर रहे हैं, ये पुराना है कैडेस्ट्रियल सर्वे होगा। केवट नंबर 1 लगान पाने वाला का नाम बाबू कालीचरण सिंह, पहले
मैंने
कालीचरण
कहा
सिंह थे,
तो 1940 के पहले का खतियान है,
वो 40 से पहले।
उसके बाद का तो खतियान नहीं है ना। देखिए आपका ऑर्डर हुआ है डेप्यूटी कमिश्नर का 1940।
लेकिन उसमें जो ऑर्डर शीट्स हम बहुत सा पढ़ते हैं, उसमें बहुत सारी चीज़ में देखा जाएगा, हमको दिला दीजिए दखल, इस तरह का लैंग्वेज।
नहीं, उससे इस तरह का लैंग्वेज से नहीं चलेगा ना। बात ये है कि भाई द कोर्ट हैज रिकॉर्डेड अ फाइंडिंग दैट दे आर द ओनर्स ऑफ द प्रॉपर्टी। दिस फाइंडिंग इज ऑल्सो प्राइमा फेसी, कोई बाइंडिंग नहीं होता है बिकॉज इट विल नॉट गेट कन्वर्टेड इनटू अ टाइटल सूट, राइट? स्टिल अ टाइटल सूट कैन बी फाइल्ड फॉर द पर्पसेस ऑफ डिक्लेरेशन ऑफ टाइटल, बट द कोर्ट हैज, after having recorded that they are the landlord of the property, there is no finding that there is a relationship of landlord and tenant. है क्या finding?
नहीं, इसमें लिखा तो है कि इसके आधार पर लैंडलॉर्ड टेनेंट रिलेशनशिप तो है।
Shall be deemed to be admitted.
इसमें ये देखा
उसमें तो there is deemed to be admitted that there is a relationship of landlord and tenant by referring to section 14.
ट्रायल कोर्ट,
ट्राई कोर्ट का आप जरा देखिए।
अपील कोर्ट का फाइंडिंग जो है भी वैसा ही। Successfully proved his status. I am of opinion that plaintiff has successfully proved his status as landlord, and in that capacity he is entitled to claim rent from the tenant. इनको लैंडलॉर्ड मान, लैंडलॉर्ड होने के लिए इवन ओनरशिप डिफॉल्ट इन पेमेंट ऑफ रेंट के लिए भी जरूरी है। देयर आर सम जजमेंट्स ऑफ आवर हाई कोर्ट ऑल्सो, पर्सनल नेसेसिटी के केस में ओनरशिप देखने की जरूरत है। उसको तो ये ऐसे भी कंसीडर नहीं, दोनों कोर्ट ने नहीं किया। और अगर जहाँ तक रेंट लेने का बात है, तो रेंट लेने के लिए तो ओनरशिप इज नॉट रिक्वायर्ड। मटेरियल कंसिडरेशन जो होना चाहिए था वो तो किए नहीं। अपीलेट कोर्ट ने भी कोई पॉइंट ऑफ डिटर्मिनेशन नहीं फ्रेम किया, जो कि मैंडेट है। मंजुला केस में माइलॉर्ड का जजमेंट भी है, पॉइंट ऑफ डिटर्मिनेशन इन्होंने नहीं कोई फ्रेम किया। 31 का कोई पॉइंट ऑफ डिटर्मिनेशन नहीं है। और इविक्शन सूट में टाइटल डिसाइड नहीं होता। ये कह रहा है कि नहीं, आपको काउंटर क्लेम फाइल करना चाहिए था। क्या काउंटर क्लेम करता है? अगर मान लीजिए इसका कोई रेंट का डिस्प्यूट होता, हमारा कुछ पैसा बाकी होता, कुछ होता कि उसको एडजस्ट कर लीजिए, ये कर लीजिए, तो
टाइटल डिक्लेरेशन के लिए तो काउंटर क्लेम नहीं होगा ना।
तो कैसे होगा? ये भी इसका एकदम अगेंस्ट द स्पिरिट ऑफ लॉ जजमेंट। टाइटल सूट ही थोड़ी है कि इसमें हमको काउंटर क्लेम करके हम अपना टाइटल मांगे। देखा जाएगा अपीलेट कोर्ट का जजमेंट क्या है। ट्रायल कोर्ट का इशू पारा 4 में ये डिस्कस किए हैं, और उसके बाद पारा 5 में 14.4 का लीगल पोजीशन इसमें लिखे हैं। हाँ, एक चीज़ ये एडिशनल लिखे हैं कि हम लोगों का कोई पिटीशन रिकॉर्ड पर है, लेकिन वो प्लेस नहीं हुआ था, इसके चलते हम इसको लीव नहीं मानते। ऐसा भी इन्होंने लिखा। पारा 6 में
क्या मतलब? बात ये है कि सेक्शन 14 का कोई
एप्लीकेशन
एप्लीकेशन
ही
नहीं,
नहीं। और
इसीलिए on the basis of the full bench judgment, if the section 14 does not apply, in the entire approach while deciding all the issues goes.
असगर बारिद के केस में मानव ऑनरेबल एपेक्स कोर्ट ने कहा कि if the approach of the appellate court is not in accordance with law,
Right.
it itself is a substantial question.
Therefore, referring to section 14 by itself is erroneous.
Yes.
And therefore, both the judgments are to be set aside and
Yes.
the matter is to be remanded.
Yes.
यही होगा,
ज़्यादा से ज़्यादा तो इसमें है।
इससे ज़्यादा तो कुछ नहीं हो सकता। उसके बाद वहाँ पर क्योंकि ये जो है आपका लैंडलॉर्ड टेनेंट रिलेशन, यू सी what is important is not the decision with regard to the title of the property. What is important is whether there was a relationship
Of
of
title.
landlord and tenant.
और
जब तक आपके पूरे एविडेंस को नहीं कंसिडर करेंगे या आपको मौका नहीं देंगे या आपने तो दिया ही होगा एविडेंस, वी डू नॉट नो व्हाट एविडेंस यू हैव गिवन, और नेगेटिव एविडेंस आप क्या ही देंगे कि हम रेंट रिसीट हमको नहीं मिला, तो इसका क्या ही नेगेटिव।
और ये सब इनका एडमिटेड भी है, ये भी ये अपने गवाही में ये कहे हैं कि दूसरा वाला जो जिस पर कि अपीलेट कोर्ट ने 2009 में जो लाया है उसके कहे हैं कि हाँ वो उसमें हमारे खिलाफ है, वो पेंडिंग है। अच्छा, इसमें कोई दूसरा प्रोसीडिंग भी एडिशनल कलेक्टर के यहाँ से आ रहा है, ये सब इनकी गवाही में है और इससे अपेरेंटली क्लियर है कि देयर इज अ डिस्प्यूट ऑफ टाइटल। तो जब जिस केसेस में जेन्युइन डिस्प्यूट ऑफ टाइटल है उसमें आप इस तरह का इविक्शन सूट ला करके आप एक ओरिजिनल आदमी को आप कैसे आप
वी कैन डू वन थिंग दैट ये जो एग्जिबिट सी का जो कॉन्सिक्वेंस है
मान
इसको कहीं पर कंसिडर नहीं किया,
ये भी नहीं कंसीडर
लिखा है लेकिन ना ट्रायल कोर्ट में कंसिडरेशन है इसका, ना ही एपीलेट कोर्ट में इसका
कंसीडरेशन
कंसिडरेशन।
एक मेजर इशू है।
सो देयरफॉर द मैटर हैज टू बी रिमांडेड टू द कोर्ट। इतना करके छोड़ देते हैं, क्वेश्चन ऑफ लॉ यही डिसाइड कर देते हैं कि सेक्शन 14 इज नॉट एप्लीकेबल एंड देयरफॉर द अप्रोच इज इनकरेक्ट।
वो वाला पार्ट पे हमको लगता है किया
दैट शुड बी सफिशिएंट।
वो जजमेंट को सेटिस्फाइड करके इसको रिमांड कर किया जा सकता है। ट्रायल कोर्ट को रिमांड करके दोनों जजमेंट सेटिस्फाइड करेंगे।
ये जो कॉम्प्लिकेटेड टाइटल डिस्प्यूट ऑफ टाइटल कैन नॉट बी डिसाइडेड इन
तो उसको
इविक्शन,
लाके तो
इसके बारे में इतना ही बोल देते हैं कि एग्जिबिट सी का कंसिडरेशन ही नहीं है बोथ द कोर्ट्स का।
और ऐसे भी राजेंद्र तिवारी के जजमेंट में 2002 सुप्रीम कोर्ट ने कहा है कि टाइटल cannot be under the domain of eviction suit. Eviction suit में टाइटल आप डिसाइड नहीं कर सकते। You go and file a proper suit. But they have filed this suit. What they will do, it is up to them. But so far as these two judgments are concerned, these two judgments are perverse and cannot be not be sustained.
देखिए सेकेंड अपील नंबर 381 ऑफ 2017, वो तिवारी वाला जजमेंट दीजिए जो ये
SCC मंगवा देते हैं।
नहीं ये वाला दैट कॉम्प्लिकेटेड क्वेश्चन ऑफ टाइटल कैन नॉट बी गॉन इनटू।
ये 2002 सुप्रीम कोर्ट सुप्रीम कोर्ट 136
2002 AIR
ये इसका
136
136 और इसका करस्पॉन्डिंग SCC है जो 2002 वॉल्यूम 1 SCC पेज 90
वॉल्यूम 1 SCC
पेज 90
90
इसको मंगवा दो।
इसको मंगाइए सर ये जजमेंट देखिए सेकेंड अपील नंबर 381 ऑफ 2017 फॉर द लंडन काउंसिल अपीयरिंग ऑन बिहाफ ऑफ द appellant।
वो वाला पार्ट भी इसमें
Nobody is
इसको
appearing.
दिया जा सकता है कि काउंटर क्लेम पर ही लिख दिए वो भी एकदम परवर्स है, erroneous है कुछ। कोई डिस्प्यूट ही नहीं है किसी तरह का, तो क्या
नहीं, we will just short, keeping it short, we will say that Exhibit C has not been considered by both the court. Impact of Exhibit C has not been considered. Appellate court has simply stated that there was no occasion to cross-examine the defense witnesses. यही खाली बोल दिए, ठीक है, तो that is not sufficient ना, उस procedural irregularity कुछ भी था, the step should have been taken at appropriate step, नहीं? I think that should be sufficient. Exhibit C का कोई consideration नहीं है, तो सारा का सारा वो
appellate court का तो बिल्कुल भी नहीं है।
appellate court में, trial court में भी, trial court में तो reference ही नहीं है। Appellate court is mentioning about this particular document एग्जिबिट सी विच वाज मार्क्ड, अब कौन सा कैसे मार्क हुआ नहीं पता.
हाँ, इसमें procedural error भी है. That is also procedural error. The proper documents has not been exhibited. That way also it is.
It is referring to this document and it was marked also, but this has not been taken into consideration. ये फाइल ये रिकॉर्ड पर है ना, ये वाला
Record पर है, लेकिन जो ये exhibit C लिखा है वो तो जो दिखा रहा है
वो तो कोई और document
वो उसका खतियान दिखा रहा है. और जबकि वो लगाए हैं उसको रिकॉर्ड में एपिलेट कोर्ट में और पेज 81 पर लगाया है.
दिखाइए सर, दिखाइए तो कहाँ है.
अभी तो हमने दिया.
ये है क्या?
इसको भी प्रॉपर्ली एग्जिबिट लिखे कुछ हैं और एग्जिबिटेड कुछ और है.
नहीं, ये वाला नहीं. कौन सा है वो?
81 पेज पर देखा. तो 2009 का जजमेंट हम निकाला.
इविक्शन अपील नंबर 2 ऑफ 2015. ये तो यही जजमेंट है ना, ये दूसरा जजमेंट है. ये तो यही इम्प्यून जजमेंट है 81. ये तो इम्प्यून जजमेंट है इसका.
हमारे पास वो जजमेंट है 2 ऑफ 2000.
नहीं, आपके जजमेंट से देख के नहीं ना होगा.
हमें मिला.
You have to be very
उसमें देखते
sure
हैं.
about this.
देख रहे हैं कैसे लिख रहे हैं. होगा जरूर लिखना. हम एग्जामिन कर लेते हैं.
आप अपने जूनियर को रिकॉर्ड देखने के लिए
हाँ, देखने एक्चुअल में हम खुद आए थे देखने के लिए.
नहीं मिला आपको?
थोड़ा देखना मिला नहीं पूरा. खुद ही देखना चाह रहा.
नहीं, आप अगर एक दिन पहले भी स्लिप देंगे ना तो आपको रिकॉर्ड मिल जाएगा.
ठीक.
इसमें कोई दिक्कत नहीं है. दे हैव ऑल बीन इंस्ट्रक्टेड कि कोई भी आदमी रिकॉर्ड मांगे तो उनको रिकॉर्ड दे देंगे.
ये भी आए थे. सेकंड अपील्स में खास करके हियरिंग मैटर में बिना रिकॉर्ड लेने के साथ
इससे दिक्कत है ना, अननेसेसरी टाइम वेस्ट होता है
टाइम
बहुत
से
सारा.
टाइम वेस्ट. हम देख लेते हैं. ऑर्डर शीट्स के साथ हो सकता है. नहीं, ये एक्चुअल में दूसरी बात लिख रहे हैं. ये सिर्फ खतियाने के बारे में लिख रहे हैं, जजमेंट के बारे में नहीं लिख रहे हैं. ये लिख रहे हैं क्या कि एग्जिबिट सी सर्टिफाइड कॉपी ऑब्टेन्ड फ्रॉम इविक्शन सूट एंड रिलेट्स टू एंट्री इन द नेम ऑफ.
और इस पर क्रॉस एग्जामिनेशन नहीं हुआ.
हाँ, इस पे
ये लिख
ये कह रहे हैं कि इस पर यह डॉक्यूमेंट आपने बाद में दिया, इस पर कोई इसको कुछ तरह
तो आपको नहीं ना, आपको जब आप कोई डॉक्यूमेंट को एडमिट कर रहे हैं तो उसका प्रोसीजर है ना.
प्रोसीजर
तो उसका कोई क्रॉस एग्जामिनेशन
Rebuttal-
करना चाहे तो कर सकता है,
रिबटल एविडेंस देना चाहिए।
हाँ कर सकता है।
लेकिन वो जजमेंट नहीं है, जो चीज ये लिख रहे हैं वो सही है। वो एग्जिबिट सी जो है दैट इज ए हथियार। लिखने से थोड़ा
हाँ
सा
इसमें लिखा हुआ है ना। एंड देन द having heard peruse and considered the petition stands allowed, the same is marked exhibit C. Then earlier the suit was fixed for argument, put up on such and such date for
हाँ, तो लेकिन
argument.
वो खाली खतियान को बना।
हाँ खतियान।
That
तो
is not
खतियान
the-
के बारे में अगर क्रॉस एग्जामिन नहीं हुआ तो that procedure should have been followed.
Yes,
And having got it exhibited and put on record,
Yes.
the court cannot say that there was no opportunity to cross examine. ये procedure follow करना चाहिए, है ना?
प्रोसीजर
इसीलिए ये फाइंडिंग दैट दे हैव अ टाइटल ओवर द प्रॉपर्टी, उसमें भी रिक्वायरमेंट है कंसिडरेशन का।
simply on the basis of some orders passed in 73
हाँ।
that funding has been recorded, and so far as the Khatian is concerned it has been brushed aside on the ground that no opportunity of
वो अलग
rebuttal-
बात है, खतियान पहले का है, वो देखेगा ट्रायल कोर्ट फिर से, उसमें हम लोग क्या
हाँ,
करेंगे? वो देखेगा, हो सकता है बाद का खतियान भी ले आया,
Yeah,
पॉसिबल नहीं।
possibility. 44 वाला तो एकदम ही इरोनियस है।
देखिए, for the learned counsel appearing on behalf of the appellant, nobody appears on behalf of the respondents. The records of the case reveal that substantial question of law was framed by this court by order dated 27/9/2018. And notice was issued upon respondent number 1 and 2. Respondent number 1 appeared through wakalatnama, but so far as respondent number 2 is concerned, the notice was served in his office. Respondent number 2 is the Deputy Commissioner, who did not even file any written statement, correct?
Yes.
Written statement before the court.
Court also treated him as a former person.
आपका फ्रेश वकालतनामा आया है?
हाँ, कल।
आ गया ना?
हाँ, सबका।
क्योंकि वो मिस्टर तिवारी बोले थे कि दैट ही कैन नॉट आर्ग्यू, देन ही वांटेड टू फाइल। The records reveal that
रिफर्ड भी नहीं है। उसमें देखने ट्रायल कोर्ट में भी नहीं देख रहे हैं, अपील कोर्ट में भी। इनका कोई ये है कुछ भी।
the records reveal that on 18/2/25 nobody had appeared on behalf of the respondents. And the matter was directed for final disposal to be taken up today. Today neither anybody is appearing on behalf of respondent number 1 nor any request for adjournment has been made by advance notice or through any counsel, any other counsel. During the course of hearing of this case, and the matter has been heard at length in absence of the respondents. The following are the four substantial questions of law formulated by the order dated 27/9/2018. The learned counsel for the appellant has submitted that the case arises out of judgment and decree dated 26/2/2015, within bracket decree signed on 13/3/2015, passed in eviction suit number 1 of 2009 by learned civil judge junior division Women to Munsif at Garhwa, against which the appeal has been dismissed by judgment and decree dated 30/5/2017, within bracket decree signed on 12/6/2017, passed by the learned principal district judge Garhwa in eviction appeal number 2 of 2015, confirming the judgment passed by the learned tribunal. The learned counsel has submitted that in spite of the appellant, in bracket the so-called tenant, having lost in both the courts, but the aforesaid substantial questions of law framed by this court are fit to be answered in favor of the appellant, and matter is fit to be remanded before the learned trial court for fresh consideration in accordance with law. He has submitted that so far as the first substantial question of law and the fourth substantial question of law are concerned, the first one is widely worded, but essentially the substantial question of law is relating to the substantial question number 4. The learned counsel submits that the plaintiff had filed a suit seeking a decree of eviction of the defendant on account of personal necessity and default in payment of rent. And for a further direction to put the plaintiff in possession through the process of court. A prayer was also made for a decree of payment of arrears of rent to the extent of ₹1,600, and a further prayer that defendant number 1 be directed to pay rent till the defendant is evicted from the suit property. He submits that since the defendant number 1 belongs to scheduled tribe category, therefore defendant number 2, the Deputy Commissioner Garhwa, was made party in the suit. However, essentially the matter was relating to the claim made by the plaintiff that the defendant number 1 was a tenant in the suit property. The learned counsel has submitted that the trial court having taken into account that there was also a plea of personal necessity, has referred to section 14 within bracket 4 of Jharkhand Building within bracket Lease, Rent and Eviction bracket close Control Act 2000, hereinafter referred to as the BBC Act, the JBC Act of 2000, and has observed that the objection raised by the defendant cannot be taken into account as no leave was taken in terms of section 14.4 to contest the suit. The learned counsel has further submitted that taking this aspect of the matter, the suit has been decreed and the case has not been decided in accordance with law.
There is no finding for default also by both the courts.
The learned counsel has submitted that neither there is any finding of default nor there is any finding of personal necessity, and by
Personal necessity का तो इनको है।
नहीं, finding मतलब वही है ना 14.4,
हाँ, बस।
nor any finding of personal necessity by giving opportunity, by scrutinizing the materials on record. And essentially these issues has been decided against the defendant by referring to section 14.4 of the JBC Act. Correct?
Treating it to be a title suit.
नहीं, ये तो default का हुआ ना. The learned counsel has further submitted that the so far as the relationship of landlord and tenant is concerned, the learned court recorded a finding that the plaintiff was landlord by referring to certain materials placed on record, and Exhibit C was totally ignored by the learned trial court. And so far as the learned appellate court is concerned, the appellate court has simply mentioned that Exhibit C was exhibited at it was exhibited belatedly and was taken on record by the learned trial court, and there was no opportunity for
The rebut.
for rebuttal by the plaintiff. As this document was filed on 14/6/2013, after examination of all the defendant witnesses, the learned counsel has submitted that Exhibit C was a material document indicating that the land was recorded in the name of ancestors of the defendant.
Tell.
Of the defendant. The learned counsel has further submitted that if the plaintiff wanted to cross-examine the defendant witnesses in connection with Exhibit C, they could have asked for further examination or cross-examination of the defendant. An appropriate petition could have been filed. The Exhibit C, having been taken on record, could not have been simply ignored by the learned trial court as well as the learned appellate. The learned counsel submits that on account of non-consideration of Exhibit C, the finding of landlord, the finding of the learned trial court that the plaintiff was the owner of the suit property and hence the landlord of the suit property, and such finding confirmed by the appellate court is itself perverse.
approach of the appellate court as well is also words.
The learned counsel submits that the appellate court has also not taken into consideration that the provision of section 14 would not apply, and
14.4.
14.4 would not apply. In the on account of the fact that the suit was filed not only on account of personal necessity but also on account of default in payment of rent. He has relied upon the judgment passed by the Honorable Full Bench of Patna High Court, reported in 1991 within bracket 2 PLJR 1 within bracket Patna FB, and has referred to para 8, 9 and 10 to submit that if the landlord chooses to join more than one ground of eviction, then under such circumstances, section 14 is not applicable. Okay?
General procedures.
And the suit has to be decided by following the general procedure. Para 15 of appellate court judgment जरा देखिए.
Para 15.
पेज नंबर 10. इसको आपको क्या बोलना है?
वही grant of leave के बारे में लिखा है.
बोले कि there is no denial, therefore leave or no leave doesn't make any difference.
इन्होंने बिल्कुल फाइंडिंग नहीं दिया डिफॉल्ट में, वो तो लिखा है. इन्होंने लिखा है कि काउंटर क्लेम को हमको करो, दैट इज फॉरवर्ड.
नहीं ये पैरा 15 तक ही है.
para 14.
15.
इन्होंने लिखा है कि the lower court has proceeded to consider section 14(4). The counsel for the appellant has drawn my attention to one petition filed before the learned lower court dated 27 March 2009. From perusal of same, it appears that the defendant had filed a petition for grant of leave to file written statement and a copy of which was also served to other side. From perusal of order sheet, it appears that the petition was never moved before the learned lower court. 14(4) of the Act says about the filing of affidavit and obtaining leave. Mere filing an affidavit by the defendant is not sufficient.
आगे पढ़िए.
PW1 and 2 have stated about tenancy, personal necessity and default by defendant. On the other hand, case of the defendant appellant is of simply denial and has not pleaded or stated about payment or non-payment of rent. Nothing has been stated to challenge the personal necessity. I consider that even if a case of plaintiff is not taken on technical ground, it stands proved on personal necessity and default by payment.
Because there is no denial.
The denial तो हमारा total ही. कि हमारा कोई रिलेशनशिप ही नहीं, टोटल देना। पेमेंट का कोई क्वेश्चन ही नहीं है, रिटर्न स्टेटमेंट में भी हम उधर रिटर्न स्टेटमेंट भी कंसिडर नहीं कर रहे हैं, इसलिए कि 14 कह रहे हैं कि उसके लाइन में कैसे करना है। पर्सनल नेसेसिटी को तो एज इट इज मान लिया ट्रायल।
Yes. The learned counsel has submitted that by resorting to the section 14 in bracket 4 of the aforesaid Act of 2000, the entire stand taken by the defendant denying the relationship of landlord and tenant and consequently denying default in payment of rent and also denying the claim of personal necessity has been totally ignored by both the courts. The learned counsel has submitted that. That should be sufficient. और एक और judgment आप rely की ना? The learned counsel has submitted that the learned courts could not have entered into complicated question of title in eviction suit and has relied upon the judgment reported in bracket 2002 bracket close 1 SCC 90. कौन सा पैराग्राफ है इसका?
Court of Controller has limited jurisdiction to try suits specified in the rent statute, and therefore it cannot pass a decree for eviction on any other ground than the one which is specified. Para 15.
Para 7 है? The learned counsel has relied upon paragraph 7 and 15 of the aforesaid judgment. 7 में है ना, it is evident that
Para 7. Question of title of the parties to the suit premises is not relevant, considering having to build up the definition. For 8 be relevant, inasmuch as both the trial court as well as first appellate court found the relationship of landlord and tenant did not exist. Further inquiry into the title of the parties having regard to nature of suit and jurisdiction are warranted. इसमें तो एग्जामिन किया है। हम इसमें इतना ही कहना चाहते थे कि कॉम्प्लिकेटेड अगर टाइटल है, इसका लिमिटेड डोमेन है, only where the landlord-tenant relationship has to be considered. Apart from that, if the issues are complicated or any title as such question is involved, then such adjudication is foreign to the scope of eviction suits. That is what my suggestion.
after hearing the learned counsel for the appellant, this court finds that it is not in dispute that the suit was filed by the plaintiff on account of default in payment of rent as well as personal necessity. This court further finds that the learned trial court had referred to section 14 within bracket 4 of the Aforesaid Act of 2000 on account of the sole reason that there was a plea of personal necessity in the judgment passed by the Honorable full bench. Reported in 1991, volume 2, PLGR, page 1, Sutra, in paragraph 8, 9 and 10, the provision of section 11 and 14 has been considered, and it has been held that where landlord chooses to join more than one ground of eviction which may include one of the grounds specified in clause C or clause E of subsection 1 of section 11 of the Act, the general provision laid down for deciding the suit shall be applicable. And it has been held in paragraph 56 of the judgment that if the plaintiff wants special procedure under section 14 of the Act that should be followed, then he must pray for eviction on the ground stated under section 11(1)(c) and E of the Act. And if he prays for eviction also on other ground, then in that case the court shall have to follow the procedure laid down in the code, and whether an issue should be tried as a preliminary issue has to be decided keeping in view order 14(2) of CPC. And the court could not have held that it could try the issue of personal necessity as a preliminary issue. In the present case, both personal necessity and default having been included for ground of eviction, this court is of the considered view that on the basis of law laid down by the Honorable Full Bench, the regular procedure of suit, the general provisions laid down for deciding the suit was to be followed. and accordingly the procedure laid down under section 14 of KBC Act would not have been resorted to by the learned trial court to refuse to consider the written statement filed by the filed by the defendant This court further finds that this aspect of the matter has not been considered by the learned appellate court as well. This court also finds that the learned trial court had decreed the suit by taking the plea of default and personal necessity as deemed admission on the part of the defendant. And the finding of the learned appellate court that the plea of non-applicability of section 14(4) was merely a technical ground and the defendant had simply denied and the case of the defendant was of simple denial is also not sustainable in the eyes of the law. As section 14 within bracket 4 essentially calls for a legal presumption of admission when the proceedings under section 14(4) is resorted to in the matter of deciding the case arising out of personal necessity. Accordingly, the substantial question of law 1 and 4 is answered in favor of the appellant and against the respondent. Number 1. So far as the other two substantial question of law number 2 and number 3 are concerned, this court finds that the learned trial court, though has referred to Exhibit C, which is the certified copy of Khatiyan,
Appellate court.
trial court has also referred in the list of documents furnished by the defendant, but there is no discussion of the Exhibit C in the entire judgment, while recording a finding that the documents and evidences produced and exhibited by the plaintiff were sufficient to suggest his entitlement for claiming the title of the landlord over the land in dispute. The finding of the learned trial court, the Exhibit C was the document in which the defendant claimed that name of the predecessor in interest of the ancestor of the defendant was recorded in the Khatiyan, which was certainly an important piece of evidence. so far as the learned appellate court is concerned, the appellate court has referred to Exhibit C, but has refused to consider the same by observing that this document was exhibited after the examination of all the defendant's witnesses. This court is of the considered view that once the document was exhibited, was taken into record by way of exhibit, its impact was required to be considered. And if so required, the witnesses could be recalled for the purposes of cross-examination or further examination with respect to such a document. Thus, the learned trial court ignored Exhibit C, and the appellate court also did not consider Exhibit C on the ground that it was placed on record after the examination of the defendant witnesses. In such circumstances, the impugned judgments recording that the plaintiff was the owner of the property and the plaintiff was to record a prima facie finding that the plaintiff was the owner of the property and he could claim to be the landlord is itself perverse. And the same, having not been considered by the learned appellate court, makes the judgment of the appellate court confirming the judgment of the learned trial court unsustainable in the eyes of law. Consequently, the this court is of the view that the law is well settled by the Honorable Supreme Court that complicated questions, disputed questions of title cannot be decided in eviction suit. But the courts have decided the point of title by ignoring Exhibit C. And the consequence of Exhibit C was certainly required to be considered in order to come to a prima facie finding with regard to the ownership, with regard to the title / the relationship of landlord and tenant between the parties. In view of the aforesaid findings, the substantial question of law number 2 and 3 are also decided in favor of the appellant and against the respondent. As a consequence of the aforesaid findings, the matter is required to be remitted back to the learned trial court for fresh consideration in accordance with law, and if required, call for further examination / cross-examination of one or the other witnesses, particularly with regard to Exhibit C. This that should be sufficient. This appeal is accordingly allowed in the aforesaid terms. दोनों को set aside कर देता हूँ. Both the judgments are hereby set aside. आपको evict तो नहीं कर दिया अभी, एग्जीक्यूशन चल रहा है आपका एग्जीक्यूशन चल रहा है, कुछ आप लोग को पता नहीं होता। कौन है रिस्पोंडेंट जो अपीयर नहीं करता है? रिस्पोंडेंट नंबर 1, हु इज ही? कौन काउंसिल है रिस्पोंडेंट नंबर 1 का? हाउ कैन यू बी सो नेग्लिजेंट? कौन है एडवोकेट रिस्पोंडेंट नंबर 1? मनोज कुमार नंबर 2।
Item 3, second field 376 of
कुछ कोटेशंस भी रहेगा, कुछ वो सारे जजमेंट्स कोट कर देंगे, ठीक है ना? जो जजमेंट्स है प्रोविजन ऑफ लॉ भी कोट कर देंगे। यस,
One substantial question of law has been raised
यस,
whether the first appeal court failed to peruse the exhibits in toto while partly allowing the first appeal in favor of the defendants and has further failed to consider the documents in correct perspective.
so which all documents have not been considered according to you? Which exhibits are involved according to you?
This D
Exhibit number, which exhibits are relevant? Exhibit number?
exhibit D2 and D3, which are the sale deeds, which are
D2,
D2 and D3,
D3.
and exhibit F, my liege.
Exhibit F. According to you, these 3 exhibits have not been considered. Is there any exhibit which has been wrongly considered? Not considered or wrongly considered. There are 2 kind of circumstances.
One thing, the documents which were submitted along with the claim, that there were 2 things, Schedule A and Schedule B. That has not been considered in the correct perspective.
Schedule
A and B.
A and B. That is not the question of law. Peruse the exhibit in toto while partly allowing the first appeal in favor of the defendants and has further failed to consider the documents in the case. We are only concerned, schedule is not the exhibit.
The document as in the claim also.
Okay.
This is part of the claim.
We will see what is the impact of D2, D3 and exhibit F.
Yes, my liege.
D3 is the sale deed
Yes, both are sale deeds.
executed by?
My liege, executed by the main vendor. This Ibrahim Taylor, he had executed these 2.
Ibrahim Taylor.
Yes, my liege.
Ibrahim Taylor. 2.
In favor of the original plaintiffs, my liege.
Original plaintiff. This is dated
My liege, 19/9/95,
90. And D3,
19/1/1998.
same vendor.
Yes, my liege.
19/9/1998. Ibrahim Taylor to original plaintiff. What is the relevance of this document?
Yes, my liege, it was the case of the plaintiffs that the entire property was consisted in Schedule A, but only the disputed property which they have separated, and that was Schedule B. So the plaintiffs, they had filed the suit only for confirmation of possession over Schedule B by declaring their right, title and interest.
Okay. So they wanted, plaintiff was seeking a declaration
The right, title and interest over the Schedule B property.
You are the plaintiff.
Yes.
Schedule B property, correct?
Yes, my lord.
Schedule B property, how did the plaintiff acquire this property?
My lord, through these two sale deeds only.
These two sentences.
Yes, my lord. The second sale
Just
deed to be moved.
acquired by D1 and D3. It was exhibited by whom?
By us only, my lord.
Why is D number given? Normally D ABCD is given for the dependents.
Yes, my lord.
Why D number has been given?
My relation for the other documents also E and
Okay.
all these.
For the plaintiff, all this ABCD has been given.
Yes.
So you, what was the case of the defendant?
Madam, the case of the defendants, two defendants, defendant number 1 and 2, their case, defendant number 1's case was that the sister of Ibrahim Taylor, who was Nasiran Khatun, she had sold some part of her share to defendant number 1, who was Pushpa Devi. And further, that one
Deed
other-
number,
Manager,
deed, date of deed,
date of deed is.
and what is the exhibit? Exhibit number.
My leadership deed dated 27/9/2002 and exhibit A.
Exhibit A. This is after the this property is included in D2 and D3.
Yes, ma'am.
So the property which was already transferred was subsequently transferred by the sister, a portion of the property. This is only deed dependent.
My lord, my leadership, one more deed, which is exhibit A by 1,
Exhibit A by 1,
deed dated 14/10/2000.
14/10/2000.
This one, both the courts have denied it because this has been transferred in favor of defendant number 2 by 1, Zarina Khatun, whose relationship with the main vendor has not been established.
Just defendant number 2
Yes, ma'am.
was
In favor
transferred
of
this
defendant number 2
by whom?
by 1 Zarina Khatun.
Zarina Khatun.
She claims to be the co-shareholder, but her relationship with the main.
What is the date? 14/10/2000.
Yes, Nalish.
This property is also included in this.
Schedule B. Yes, Nalish.
This property is also included in the earlier deed dated 1995 and this.
Yes.
So basically, the entire property was transferred by Ibrahim Taylor, and then the two sisters and one relation, so called, they transferred part of the property. So was it a joint family property?
Nalish, this property, the main person was one father named Shamsuddin Khalifa. So he sold the property to his wife, once infant baby, and through inheritance, this Ibrahim Taylor got it, but he was paying the rent and he was in possession.
That's
And
right. He might be in possession, but it was a property which was not yet partitioned.
Yes, Nalish.
Correct? Then under such circumstances, if one of the family member, this Muslim, they are governed by Muslim law, Muslims,
Yes, Nalish.
one of the family members sells the entire property, what is the consequence? He will sell only his portion of the property.
Yes, Nalish.
Then
So these two, they were related, brother and sister. So in Muslim law, the females get 1/3 portion of whatever the males get my lord. So this first deed by which she has transferred, she is claiming that she has sold her property, but that is in 2002, much after.
How does that make a difference? Because some earlier deed would be confined only to his share. If there is a dispute as to whether, because Ibrahim Taylor had no right to sell the entire property, but this particular deed was not under challenge.
No, my lordship, the 98 and 95 deed have never been challenged, and neither has his sister ever come and means they have stated that she has relinquished her right in the property and she is living with in her in-laws place. She has never been examined, she has never come anywhere, and only these defendant number 1 and 2, it is our case that these deeds are forged, my leadership.
Which deeds?
These the ones that are exhibited by defendant number 1 and 2.
Forged.
Yes, my leadership.
So you challenge its validity.
No, my leadership will not challenge its
As
validity.
a plaintiff, you have not challenged its validity.
We got to know about it only during this.
That's right, but you never challenged its validity.
Yes, my leadership. And my leadership, the husband of the defendant number 1, his name is Upendra Kumar, and he has also been examined as defendant witness number 1. He has stated and he has brought on record in his own evidence one examination done in one other title suit dated 46 of 2007. That suit was filed by this husband for specific performance of one contract of sale of the same property. So in that we are the defendants. So the court has held that he has already through filing the suit and giving the evidence, he has accepted that we were the owners.
So who is he to accept? This lady was also a party in this one.
No, my lordship, he has not made her party.
Might not have. So that will not bind the lady. Will it bind the lady?
Yes, my lordship.
That will not bind the lady. Let us see the findings and the issue straight. This initial court's judgment is in Hindi. Let us see the appellate court's finding.
The issue is framed in the initial court that has been reiterated in
Paragraph 5.
Yes, yes.
The appellate court must have summarized the findings of the learned trial court.
Yes, my
Please let us know if there is any error in that.
lordship. Yes, my lordship.
The title suit was for declaration of title.
Yes, my lordship. Over properties in Schedule B, that is 0.61 decimal.
What is the finding of the learned appellate court? Is there any discussion of these two documents?
Yes, my lordship. They have not been denied or they have not been.
Where is the finding?
My lordship, para 10.
Yes.
My lordship, if I may just read this para 10. The plaintiffs have filed title suit number 100 of 2003 for a decree of confirmation of their possession over the Schedule B property, that is 0.61 decimals, 6 shatraks of land under plot number 4321, 4322 and 4323 under new holding number 127, 128 corresponding to the old municipal holding numbers 111, 112, 113 under new ward number 26, old ward number 6 of Dhanbad municipality, Dhanbad, PS and district Dhanbad, and recovery of possession if they are found dispossessed from the suit property, that is Schedule B land, and pleading that they have purchased the suit property of Schedule A land through the sale deed executed by Mohammed Ibrahim Taylor in the year 1995 and 1998, white sale deed number 5013 dated 19/2/95, that is D2, and sale deed number 6794 dated 9/1/98, that is exhibit D3. The sold property along with Schedule A belonged to one Samsuddin Khalifa, who had acquired the same through a registered sale deed number 10393 of 1995 and 9746 of 1960, as well as registered gift number 3904 of 1954. White sale deed number 12511 dated 22/7/65, he has transferred the sold property Schedule B land along with Schedule A land to his wife Sarifan. Sarifan died in the year 1974-75, leaving behind her son Muhammad.
Just pause here for a moment. Till here there is no dispute. Right? So property stood in the name of Sarifan. Continue.
Her son Muhammad Ibrahim Taylor and a daughter namely Nasiran Khatun, who is the vendor of 1/3 share to defendant number 1, Srimati Pushpa Devi. It is the case of the plaintiff's respondents that they got their name mutated in the register of the state and were paying rent to the government in lieu of the possession of their purchased property. They were also paying holding tax to the Bihar municipality. White order dated 3/10/7. Bindu Agarwal, defendant number 3, and Sanjay Eliwal, defendant number 4, were added as defendants in the suit, who have put forward the case that they have purchased Schedule A land through registered sale deed number 9312 and 9313, dated 31/6/2006 from the plaintiffs. Certain facts are admitted by both the sides in this case. It is admitted that Samsuddin Khalifa has acquired Schedule A land by virtue of registered sale deed and registered gift deed. It is also admitted that he has transferred the Schedule A land to his wife Sarifan, while registered sale deed number 12511 dated 22/7/1965. It is admitted that Sarifan died leaving behind her son Muhammad Taylor and married daughter Nasiran Khatun. The bone of contention between the plaintiffs and contestant defendant number 1 and 2 is that, as per the case of the plaintiffs, Nasiran Khatun was living in her in-laws' house and she has relinquished her claim share in Schedule A land. Muhammad Ibrahim Taylor became the sole owner of the sold property, that is Schedule A land, and sold 1 kattha 7 chataks or 2.38 decibels out of 1/4 kattha of land under plot 4321, 4322, 4323 under new holding number 126, 127, 128, old holding number 111, 112, 113 under new ward number 26, old ward number 6 of Dhanbad municipality, Dhanbad PS and district Dhanbad. White sale deed number 5013 dated 19/9/95. The plaintiffs have acquired 17 chataks or 885 square feet in plot number 4323 from Mohammed Ibrahim Taylor, white sale deed number 6794 dated 9/11/98, which is exhibit D3. The case of the contestant defendants, appellant number 1 and 2, is that Pushpa Devi, defendant number 1, has purchased 1/3 share or 12 chataks under the above mentioned suit property of Nasiran Khatun, sister of the plaintiff, in the suit property Schedule B on payment of voluntary consideration, white sale deed number 5280, dated 27/9/2002, which is exhibit A. It is further the case of defendant number 1 and 2, the appellants, that Nasiran Khatun has never relinquished her right, title, interest and possession over the suit property. This issue was decided by the learned court in issue number 6, whether Sarifan Khatun has relinquished her share in the suit property against the plaintiffs. Defendant number 3 and 4 have supported the case of the plaintiffs respondents. In the above background of the case, I have gone through at the first the oral evidence on record. Ram Chandra Kuwar, PW1, is the father of the plaintiff. He has stated about the case of the plaintiffs in his examination in chief.
Now you come to the finding of the
Yes, ma'am.
straight away today. Is there any finding of relinquishment?
My relation, even in the court below, in the first court, in one issue it has been decided that she has not relinquished, and in one it has been decided that she has relinquished.
What is the finding of the appellate court? Appellate court is also a court of fact. What is the finding of that?
It has found that she has not relinquished. My relation.
Where is that finding?
Relation 16. Actually, my relation from 15 only.
On the basis of the above discussion and in want of any documentary evidence on record, it can be safely held that Nasrinan Khatun has not relinquished her right title over the property. Correct?
Yes, my relation. Because of this. only
Because
it was
relinquishment also is an act of transfer, right? It is required to be through a document. It cannot be just you just say that somebody has relinquished it. And she did not join in execution of deed by Ibrahim, right? She did not join. So what is the error in this finding? And if she had not relinquished it, then the sale transfer by Ibrahim is confined to 2/3 only. There is a clear finding that she had not relinquished it. Show me how is it perverse, to which document it is perverse, because that is the point of law formulated. Tell us.
In the plate, we have only asked for a relief for Schedule B property.
Schedule B is relatable to which sale deed?
My relation, the second sale deed.
Not Exhibit A.
No.
Schedule B is relatable to Exhibit A by 1.
Yes, my relation.
Is there any finding that, what about the finding with regard to A by 1?
Yes, my relation, the appellate court's judgment in para 18, that is the finding.
As per sale deed dated 3406, sale deed number Exhibit A by 1, Rojini Bibi died leaving behind her daughter Zarina Khatun. Who is Rojini Bibi?
Her relationship has not been established with the main person, my relation. There is nothing on record to show that Zarina Khatun is in any way related with Samsuddin Khalifa, or she is heir or successor, or for that matter, tenant in common of Samsuddin Khalifa. But it is admitted from both sides that Nasiran Khatun is the daughter of Samsuddin Khalifa, and she is the sister of Ibrahim Taylor. I should just para 18, if I may be allowed to read my relation of the appellate court's judgment.
Just a moment. Now come to para 17, dealing with Exhibit A by 1. Exhibit A by 1, Rosni Bibi died leaving behind.
Rosni Bibi died leaving behind her daughter Zarina Khatun, who had executed sale deed A by 1 in favor of Vijay Kumar Singh, which is defendant number 2, on consideration amount of Rs 55,000 for an area of 0.61 acres, including 2 rooms, under plot number 4321, 4322 and 4323, under new ward number 26, holding number 127 and 158. There is nothing on record to show that Zarina Khatun is in any way related with Samsuddin Khalifa, or she is the heir or successor, or for that matter, tenant in common of Samsuddin Khalifa. But it is admitted that from both sides that Nasiran Khatun is the daughter of Samsuddin Khalifa, and she is the sister of Ibrahim Taylor. As per settled principles of Mohammedan law, on death of Sarifan, she is entitled for 1/3 of her share of her property, which she has sold to Pushpa Singh while registered sale deed number 5280 dated 27/9/2002 Exhibit A. It is mentioned in the sale deed that she had sold 3/4 kattha, that is 1.23 decimals or 12 chataks of land. As per the plaintiff's case, the original total area of lot of 4321, 4322, 4323 was 1/4 kattha, out of which Nasiran has sold 3/4 kattha, that is 1.23 decimals, to Pushpa Singh, apparently her 1/3 share. Plaintiffs' respondents have brought this suit for confirmation of the possession of Schedule B land, that is 0.61 decimals of land, under plot 4321, 4322 and 4323 with specific boundary as in North Book Corner, in South Neelu Agarwal, in East Gully and in West Kailash Agarwal, purchased by defendant number 2, Vijay Kumar Singh, while sale deed number 3406 dated 14/10/2002. This is actually 2000 Malaysia, but it is wrongly mentioned as 2002, which is Exhibit A by 1. I have already held that there is nothing on record to show that Zarina Khatun is in any way related with Samsudin Khalifa. There is nothing on record to show that she is the legal heir and successor or tenant in common with Samsudin Khalifa. The specific case of the plaintiff respondents is that they want a relief of confirmation of possession over Schedule B land, which is purchased by Vijay Kumar Singh through registered deed number 3406 dated 14/10/2000. Vijay Kumar Singh has not been examined and as held earlier by this court, his vendor Zarina Khatun is not related with Samsudin Khalifa. As far as sale deed number 5280 dated 27/9/2002 Exhibit A is concerned, Nazira Khatun has sold her 1/3 share in property to Pushpa Singh, which she had every right to sell. As per settled principles of law, the plaintiffs can succeed only by making out their title and entitlement to possession and not on any alleged weakness in the title or possession of the defendant. The reliance may be placed upon the case of T.K. Muhammad Abu Bakr, led through LRs, and others versus PSN Ahmad Abdul Khadir and others as reported in 2009-77 AIC to SC on the case of Union of India and others versus Vasavi Cooperative Housing Society Limited and others reported in EIR 2014 Supreme Court 1937, and also the case of Nirmala Devi and others versus Ram Sahai and others reported in EIR 2004 Allahabad. The case of Chiranjeev Rao Mehra and others, Srimati Kamal Saroj Mahajan and others decided by Honorable Supreme Court on 11/3/2005 in SMB Civil number 20914 of 2004, the case before the Honorable Apex Court was regarding the rental property. The respondent number 1 in that case had filed a suit for eviction, arrears of rent and damages, mean profits against the defendant petitioner. The case at hand is altogether different facts, so this citation is of no use to the plaintiff respondents. Likewise, the case of Uttam Singh Buddhar, etc., was related with dispute regarding debit, which was claimed illegal.
You are the plaintiff. You wanted declaration of title in connection with Schedule B property. That has been declared.
Yes, my lordship, that has been declared, but this finding, my lordship,
Which finding is troubling you?
we never asked for this only, my lordship, whether Nazira Khatun, whether she has relinquished it or not.
Need not be. Need not be. You see, the court has said that Nashiran Khatun had the right to sell 1/3 of it. And this has come on record that there was no relinquishment. Therefore, under such circumstances, your title is declared only in connection with the title of the vendor. That's it. So, how do you say that these documents have not been considered? Every document has been duly considered. That is a question of law you have framed. You see, exhibit A by 1 is of no use, correct? Right? And this document has all your sale deeds have been considered. Tell us which document has not been considered. Yes, respondent. Which document has not been considered?
No, Your Lordship, the question is absolutely that none of the documents of the
Yes,
were
this is the
considered.
question
That
also.
is the question that was raised.
Yes.
Now, from perusal of para 16 onwards, Your Lordship would find that the appellate court has actually considered all the documents. Now,
Exhibit
whenever
A by 1 has been considered.
now,
It has been held that it is not in dispute that she was a sister.
so whenever a person, appellant says that a particular document has not been considered, he or she has to specifically point out which was that document. If it would have been considered, then the entire fate of the appeal itself would have changed.
Yes.
That is the impact they were required to show. Not a general statement that the documents were not considered. They have to show as to which document, if was wrongly considered or if it would have been considered, the fate would have been different. No such thing has been pointed out. And Your Lordship, one thing, that the appellate court has rightly, it has only set aside the finding of the trial court only with regard to the sale deed executed by Nasir and Khatun. That is all.
That's it.
Because she had the right to transfer 1/3, and this is not in dispute. That she was one of the heir, and being a daughter, she had 1/3, and the 2/3 would go to the.
And therefore, the appellate court has confined the decree.
Absolutely,
Uh,
absolutely.
0.61 is 2/3.
Yes, absolutely.
0.61 is 2/3, madam. 0.61 decimal constitutes 2/3. How much does it constitute? How much does this area constitute?
My lord, this is 6 chataks of land. 1/3 is said to be 12 chataks of land.
You just tell us what is the total area was how much?
1 kattha and 7 chataks. 2.38 decimals.
The total area was?
Total area was 2.38 decimals. My lord.
How much is 1/3? 1/3 of 2.38 is how much? If total area is of Schedule A, what is the total area of Schedule A? Because Schedule B is a part of Schedule
Yes,
A.
yes, my lord.
2.38. What is the 1/3? The only area which could have been excluded was 1/3, isn't it?
Yes.
So
No doubt.
what should be the remaining area? टू 2.38 का 1/3 कितना होता है?
About 0.79 decimals.
Where are you seeing? ये 0.61 कहाँ से उठा के लेके आए? Oh, since they had sought for confirmation only with regard to 0.61, that is why 0.61 is there. See, if you have any further area to be claimed, that is not included because you never claimed. There could be some more area to it because 1/3 would be more than 0.61. Yes, Mr. Rahul. It seems that since they had sought confirmation of only 0.61, the suit was fully decreed in their favor. Suit was fully decreed.
And they have filed the appeal. Defendant number 1 and 2 have filed the appeal. And even in the
Who are you?
We are the plaintiffs.
Plaintiff, why have you filed this appeal?
My
Your
lordship,
suit was fully decreed.
yes, my lordship,
Yes.
only this observation
Which observation?
that Nasiran Khatun has rightly sold my lordship, but and as of now, these properties they have already been transferred.
We don't know about it.
Your Lordship, as on date, the question of law is that the documents were not considered.
No, everything has
That
been
is,
considered.
so everything has been considered.
Everything has been considered and your suit has been fully decreed. Because you claimed right only with respect to 0.61 decimal. And since there was also a claim that somebody has sold it, you also claimed that you joined issues on that there was a relinquishment. And there is a finding that there was no relinquishment. So your title with respect to Schedule P has been declared.
And the appellate court also, in para 17, it has said that Zarina Khatun, whatever she had sold, that was not related in any way, and that decree has not been
Yes.
upset with regard to that.
Not at all. Whatever she has sold, that portion has not been included. And there is no finding also by the learned appellate court with this, with respect to Exhibit A.
No,
Exhibit
that
A by
finding-
1. A
that-
by 1 is not
that-
there.
No, it is not there. In page 21,
Yes.
rather a finding is against me. Page 21, last 5 lines. There is nothing on record to show that Zarina Khatun is in any way related with Shamsuddin, or she is the heir of successor of so-and-so, of Shamsuddin Khalifa, but it is admitted by both the sides that Nasiran Khatun
Yes,
is
she is
the
a
daughter
sister.
of Shamsuddin Khalifa. So,
जबरदस्ती वाला बन गया वो इसका मतलब
As of now, the entire property in
we
Schedule
are
A.
not bothered about it. We are only bothered about our question.
Because this observation regarding Nasiran Khatun leadership that affects the purchasers, defendant number 3 and 4.
They are not here. The appellant before us.
They are here, my lady.
They must be here, but they are not the appellant before us. If it is affecting defendant number 4, they are not the appellant before us. They are not concerned with this. Second appeal number 376 of 2019. So एक meeting है second appeal.
can your Lordship keep it tomorrow then?
For what?
For only these calculations, otherwise there are minute calculations with regard to the decimals and all those. Your Lordship may keep it at 10:30.
I will then record your
Only to
submissions.
properly assess, nothing else.
ठीक है फिर कल रख देते हैं.
Kal-
The case has been fully heard. The learned counsel for the respondent has submitted that the matter be posted tomorrow for the purposes of clarification in connection with the area of the property.
Yes.
Yes, however, it transpires from the appellate court judgment that the right title interest of the plaintiff was duly decided in favor of was fully decided in favor of the plaintiff, inasmuch as the plaintiff had sought declaration only in connection with Schedule B property, which was for an area of 0.61 decimal. That's it. Babat. And there has been a further observation by a further finding by the learned trial court that Nasiran Khatun had the right to sell 1/3 of the
And she had not.
entire shoot land.
Both the courts concurrently held that Nasiran had not, she had 1/3 right and she had not relinquished. Both concurrently.
And there is a concurrent finding that Nasiran Khatun never relinquished her 1/3 share.
And as a defendant, Your Lordship, I have a right to protect and to show that there is a Supreme Court judgment on that basis. I am saying that if you, as Your Lordship observed, that when a person transfer the property, it would be to the extent of the right which he has over the property.
Yes, nothing more.
And as a dependent, I can always protect that or show that the extra portion which was transferred was not binding on me. I can show, and that judgment is.
Why do you need that judgment here? You see, plaintiff had only claim for this.
Yes, yes.
We are not concerned with that. We are not deciding your rights.
No.
Nor we are deciding the rights of anybody else. उनका जो claim था, उनका 1/3 का claim था, वो जो भी उनका schedule B का था वो तो उनका declare हो गया. बाकी से related अगर उनको कोई declaration चाहिए, that would be a separate suit, because this is only confined to this.
ठीक है. Your Lordship may keep it tomorrow.
At the request of the learned counsel for the respondents, post this case for further hearing tomorrow at 10:30. आप आ जाइएगा.